Grab your coffee and let's get into court.
Good morning. Hi, Nicole. The weather, sorry, it's on my phone. The weather is just freezing. Like there's still snow, so cold. But as far as like a wind and thunderstorms, I think we're past that. So fingers crossed, we should be good. How is the audio? I was how's it sound? I think hands got on my microphone and there's like little knobs. So how's it sound? Let me know. Okay, good. They call this my talking. They say, "Are you going to do your talking today?" Okay, so Kelsey Fitzsimmons had 2 pretrial hearings that we need to go over to get ready for trial. But right now, there's a pretrial hearing that's happening live. So my original plan was to watch the first one back in time that we missed. So the latest, and work our way up to date to get ready for trial. So I was planning on doing the latest one today and then the most recent one tomorrow. But now we have a third one that's going on right now. So we could watch now, or we could do like start backwards, work more current. It doesn't really bother me. I haven't watched any of them. What I will say is that the hearing that I planned on watching today, it's only like 40 minutes, but the audio is not great in the courtroom. So I think you can hear the attorneys fine, but there is like a background noise. The judge is a little bit hard to hear, but that's just how this courtroom is. I don't think it's set up really well by like the pool camera, whoever's in there. I don't think they have like audio on all the tables, so it's just what the camera is picking up. But I feel like if everybody wants to stick with my original plan, and we'll go back to the February 27th hearing. It's only about 45 minutes. And then we'll work our way up to current. That way it goes in chronological order. I feel like that first one is about Justin Alain, the ex-fiance, breaking and entering. And then like each hearing since, I feel like builds on that topic. So it only makes sense to go in chronological order. And we should be caught up by Friday then and ready for trial Monday if it goes. So just a warning, the audio in the courtroom is not the best. It is not the worst either, but it definitely is not the best. So I'm going to get court pulled up. Again, this is the February 27th hearing. Only like 45 minutes. We'll stop, pause, talk about it. I'm assuming all of you know about the Kelsey Fitzsimmons story. It's another story out of Massachusetts. Her attorney, Tim Bradle, also represents Aiden Carney, aka Turtle Boy. She was a North Andover police officer. Her ex-fiance was a North Andover firefighter. Seems like she was experiencing postpartum depression, and her baby was like, 3 months old. There was a little bit of turmoil in the relationship, but it seems like her state of mind at the time was that they were separated. In fact, he was no longer living at her house. It was a house owned by her. And he went behind her back and got a temporary restraining order. And her police department and partner, Officer Noonan, came to serve the restraining order on her. And from the way it sounds, it was like some grand conspiracy between the North Andover Police Department and Justin Alain, the ex-fiance. So we're going to get a lot of background in these hearings leading up. We are so back, Abby. But I'm assuming you guys all know Kelsey's story. If not, I have a highlight over on my IG that has everything from the very beginning. So let's get court pulled up. And like I said, we should be done in like an hour here because it's not a long hearing. And it just makes sense to split them up over a couple of days. But like I said, the audio is not the best. We will have to make do with it. Okay, let's see here. Okay, Nicole, actually, let's go through the chat a minute. If anybody has questions before we start, you can go ahead and throw them in the chat and I'll answer them. Nicole said, I know that it isn't a common situation, but feels like some kind of conflict of interest to have her own partner serve her the papers. Yeah, and there is some backstory to them. Like her postpartum depression was triggered by a call that her and Officer Noonan went on during her pregnancy that involved a baby, a newborn baby, and some kind of domestic dispute. So like he had a personal knowledge of that incident that triggered her and spiraled to the point where she was even on like temporary leave from the police department. So it's very much a conflict of interest, and Attorney Bradel gets into it at some point on these hearings. Now, I have not watched all of these hearings, but I have seen reporting on it. So I have a little bit of insight, but this will be a first watch for me personally. When I was looking for the stream last night, that's how I knew the audio was bad. It just didn't sound good. But like also Justin had went for a temporary restraining order that day on Kelsey. And then they had him in her basement hiding to take the baby when they served the papers. Like she went upstairs and they let Justin go in the basement and handed him the baby. Why is he anywhere around her if he has a restraining order? That just blows my mind. There's so many pieces to this that don't add up, don't make sense. And sounds like they might go bench trial. And a lot of people have asked me my opinion on that. I think it might be the smarter option because we are looking at a reasonable doubt standard, and it's 100% he said, she said. There's postpartum depression, there's anxiety, there's suicide. It sounds like the state's new theory is suicide by cop, so that should be interesting. There's just so many emotions at play that I think a judge might be better at following the reasonable doubt standard, eliminating all of the outside noise and emotions, and just listening to what's presented. And this judge does seem really nice and really fair, which I think helps the situation that she should. Oh, wait. Let's go back. Okay. It's really weird. This stream like just starts in the middle of people talking. I don't know. It is what it is. It's the only stream I could find from that hearing. Fingers crossed everything goes smoothly. I guess we're not in trial, so if we have any little hiccups with the pausing, we'll just wait and work through it. Nicole also said, my mama heart breaks for her. She was failed by so many people in her life that she trusted. Yeah, I'm just never going to get over the fact that her own department came knowing she had mental health struggles and didn't have like a social worker or somebody on board to help process these feelings, because that seems to only make sense. Whether at trial we learn if there's protocol for that or what, I don't know. I don't know what's going to come in at trial. We know the narrative from the defense. We know the narrative from the state. Sounds like they're going suicide by cop, which is bizarre in and of itself. But I definitely, like, we just don't know the way the evidence is going to come out. So I guess that's what makes this trial kind of exciting, because who knows who we're going to hear from. Anyways, let's get into court. Like I said, this stream randomly just starts in the middle of somebody talking, and it is what it is. I'm going to have the audio cranked. Like I said, sounds not the best, but we're just going to roll it.
Related to that. And that's my agenda. I don't know if you folks had other things that you were anticipating or wanted to raise. Anything? No? Did I miss anything?
No, I think you covered it.
All right.
I do have a few things.
Sure.
So we have a.
One thing I want to say real quick is the prosecutor gives major D-bag vibes. Like, I think he's so condescending. He's so rude. He's so demeaning. I do not like this prosecutor. Let me know your thoughts as it plays out. But he is just like, T. Like, everything Bradel says, he wants to chomp back. And it's just like, I don't know. It's giving like high school girl drama. But back to court.
Long list of things that we consider to be outstanding discovery, so I think we have a Rule 14 issue, and counsel and I have been going back and forth on it, but I don't think that there's been enough digging, frankly, about some of the stuff we're looking for.
All right, so I'll tell you what, so that will be part of our discovery agenda. All right, we'll do that. I'm not cutting you off. I'm just trying to get an idea of what lays ahead. But yes, I do want to get out in front of the anticipated discovery issues, including the motions that were filed. But,
sure. And Judge, on that bail motion, I certainly want to give the Commonwealth time to look at it and react.
On the what?
The bail motion that I requested.
I saw something. I have not read it. I don't know if Mr. Gubitosi shared. I had a charge conference this morning in a trial that's been before me for 5 weeks. It's going to the jury on Monday, and I just haven't had time.
Sure.
So if there was something filed this morning, I didn't see it.
Sure.
We can talk about. Yeah, but you said it's bail related.
It is, Judge. It just whenever you're ready to address it, but there's just some pressing aspects of her terms of release that are really hindering our trial prep.
Okay, well, I think, so I'll tell you this, I have read the materials that are in the file. I don't know anything else.
Okay, so what we do know from that bail motion is that Kelsey was living at her parents' house. She had to have like a several day notice to the probation to get permission to go meet at the attorney's office. And Bradel was asking that there be like a 2-hour time window where she can get permission to go meet with him because, like attorneys, they're busy and time's limited. So if he has an open 2 hours to meet with Kelsey, he wanted her to be able to quickly get permission and go meet with him at his office. Another part was like her mom had to drive her there, so her mom had to be available for her. So he was asking for some bail modifications. In this hearing, they have not yet addressed that because it was just filed. So a lot of you probably have seen the reporting since about the bail motion, but at this point in the hearing, they are just now addressing that it was just filed.
Else about the case other than what's in the file. But my memory is that wasn't there a 58A order?
Yes, Your Honor.
And so if there's any changes that need to be made to that order, I believe the law requires it to go before the judge that imposed the conditions. Is the defendant out on conditions of release?
She is, Your Honor. That's correct.
And that judge would have been Judge McCarthy Neiman, the one who randomly threw her back in jail.
Okay. So, yeah, I mean,
So that's going to trigger a recusal hearing, Your Honor. We have a request for an evidentiary hearing that Judge Ricciuti, the Chief Justice of the Superior Court, took over and he ruled that my motion to recuse the prior judge was moot because she was not going to, essentially, because she was not going to be around in the sessions. So this is a.
Let me first get to this that you're talking about.
Sure.
Mr. Royan, let me get the motion. So this is paper 54, defendant's renewed motion for bail determination under section 5787 or chapter 276. So you say.
So we're asking for a revised bail determination. That's correct, Your Honor.
Okay. Yeah, in other words, a change in the conditions of release or something?
Yes, that's correct. The document 51 in the docket, Your Honor, is our just filed. The prior substantive motion we filed was a motion to recuse Judge McCarthy-Nyman from the case.
Okay. So let me first see if there's even an issue. So
sure.
Mr. Gubitosi, you presumably have seen this motion?
Yes, I got it late this morning.
All right. Leaving aside whether today is the appropriate time for it to be heard or not, what is the Commonwealth's position is? Should it be heard by Judge McCarthy or?
Well, yes. At the end of the day, there was a number of hearings in front of Judge McCarthy. The defendant appealed her decision to the SJC. The SJC denied the appeal, saying she did not abuse her discretion. That's where it stands now.
Which it's just like so. It's like so apparent what they're trying to do here because they want this bail modification to go back in front of McCarthy-Nyman. When last time Pretrial asked for a modification of her bail, she randomly threw her back in jail with no reasoning for it. So, like, of course, the prosecution wants it to go back in front of her. Why wouldn't they? But it's like, why are they opposing this judge, who's a fair judge, hearing a motion? It's like they're picking and choosing, and it's just giving off so corrupt. And it's giving like Hank Brennan and Lally needing Judge Bev to win their case for them, and it failed miserably. The prosecution, it shouldn't matter what judge hears the motion. We assume they're all going to follow the law and make the right decision, but it's so telling they want this to go back in front of the witch who threw her back in jail.
Defense counsel did file a motion to recuse Judge McCarthy. As counsel said, can't remember the name of the judge.
Ricciuti. Okay.
Yes, deemed it moot because he asked her to get off the case, not anything else, just to get off the case. That's what the defense counsel was asking for. Because she wasn't in the trial session, she wasn't going to be the trial judge, so none of that was acted upon. And so, but there's been an extensive history that the judge has dealt with, and frankly, I don't see a change in circumstances anyway. So.
Well, let me
I would point to document 51 for a change in circumstances, Your Honor, about the true nature of what's been going on in this case.
Okay, so let me say this. I like to have practical results and be pragmatic as pragmatic as the rules and the law allow me to. So I don't. Is it something?
The judge is like, I'm not understanding why you're opposing me hearing this motion when it just makes sense. Like, I'm assigned to this case. Why are you being difficult? Like, that's essentially what the judge is telling him right now.
That you would object to me hearing or something. If I have the legal authority, if you folks agree that I have the legal authority to weigh in on it, I don't know that today would be the appropriate day to do it or not, but we can talk about that.
I appreciate you being open to that, Judge, and I can narrow it, in terms of what I want to impose a little bit on the court and the council today to deal with is, some of these terms are duplicative and they're just bureaucratic. They're just onerous. And, 48 hours notice to make an appointment to come to my office. I don't know when I'm going to be in my office within 48 hours, and I need to have Ms. Fitzsimmons more at my, when I need her to prep. And so the idea of giving 48 hours notice to probation, to leave house arrest, to come to my office in Boston is just extremely onerous. Also.
And the prepping is crucial here because this case is 100% he said, she said. So Kelsey is going to have to testify. And that trial prep, like the amount of time you need to fully prep for your testimony as a defendant and to be able to handle cross-examination, it's paramount when that's her defense, is her own words.
So she's in the custody.
Let me just, because there's a couple different issues. One is whether, because I don't want to waste your time if it, in the sense that if it's something that does need to go to trial. So I guess what is the Commonwealth's position? Presumably the defense position is that I can hear.
Again, for the second time, he's like asking the Commonwealth, what's your position? Like he's almost giving them the opportunity to quit fighting it and say, yeah, you can hear the motion. And the Commonwealth just does not want that to happen. But again, he's giving them the opportunity.
Yes. And I should hear.
You should. Well, our position is that she should be recused. We're more than willing, ready, willing, and able, and happy to have an evidentiary hearing on it. I don't think the Superior Court wants that on her recusal. And we think that the entire framework of this case has been an absolute circus from the beginning. And I'm glad you're here, frankly. And
whatever.
I have a pending motion to recuse. Well, not pending, but I filed a motion to recuse, Judge. And I am very unhappy with the way this thing has unfolded since arraignment. And we have moved to recuse. Judge Ricciuti, I think wisely, has made it a non-issue. And I want to forge ahead with Your Honor. And I want to go ahead with the case on all aspects with Your Honor. And I don't think it's in the Superior Court's best interest. I don't think it's in Kelsey's best interest. I don't think it's in anybody's best interest to kick this back to where it just came out of. And I just want to ask for a few things today. And I know that, the court can say no, you got to wait. The Commonwealth can say no, you got to wait. But I think these things are not unreasonable. I just want to get rid of the 48-hour notice. I want her to be able to come to my office, get in a car and drive there on her own, like a grown-up. Her mom is the custodian of Miss Fitzsimmons. Her mom works full-time. This has been an incredible hardship on her. She's got to drive her to my office and sit around for 3 hours. Really unfair.
Let's do this. Before we end today, we will address whether I will address it or not. And the reason why is because I like to read it. When attorneys take the time, either side, take the time to write something and file it, I like to read it. And I haven't read it, and I appreciate it. I'm really at a loss.
Like, this judge is just so good because the amount of times during Karen Reed's trial that the defense would get up to argue something, and the questions from Judge Bev were as if she had never read the papers. She had no idea what they were talking about. Like, this judge is so thorough, and like, I appreciate a good judge who's like, I need to read this, but I'm willing, ready, and able to take this motion and address it. Tegan said, are we liking her lawyer? I personally love Tim Bradle. He is so passionate, and like, he genuinely gets emotional. Hang on a minute. And he's so passionate for his clients. He fights hard. It does seem like he's stumbling a little bit on his words, but he is so passionate about this case that he's like emotionally invested at this point. So I think he gets caught up like in his attorneying and his like personal emotions to it.
Without knowing, so we'll need probation up here if we get to that point. But in any event, we'll circle back. I don't want to start on something that. Let's just start looking forward instead of back.
I love the idea.
We'll do that. So in any event, all right. So let's talk about legal and evidentiary issues, and just in the sense of deadlines. What I would like is a joint witness list, actually, I'd like a joint witness list because what I intend to do is treat this case like any other criminal case I preside over, and that is there will be individual voir dire, there will be attorney-conducted voir dire, and there will be a questionnaire.
Taken, both of her attorneys are private defense counsel that's hired, and she also had or still has a give send go that I think had over $100,000. So she retained Tim Bradel, but since then I think she's mainly been funding it through public donations. But Tim Bradel is so passionate about this case, and really any case he takes, I think he would do it pro bono if the funds were gone. This is a case that is very clearly driven by motivation of governmental actors, the North Andover Police Department, the DA protecting them. And then you also have like Justin Alain's connections to all these people. And it sounds like Justin is connected to just the right people to have this play out.
That's kind of my standard procedure. Mr. I won't keep the Friday case in front of me, but I know your staff has, so.
I have.
Oh, you have?
Yes.
Oh, okay. All right. So
I guess
you must have
not
done
that
such a good job that I don't remember. But in any event, so that's where we're going. So the reason why I bring that up is because one of the questions that will be on that case-specific juror questionnaire will be, do you know any of these potential witnesses? And what I like to do is just attach some Word document or something that has both of your witness lists, both of your witnesses on, both sides' witnesses on there. Also, on there, we should list, the way it will be phrased is it will be potential witnesses and anyone possibly associated with the case. So if there's names of folks that their names may be prominent during the trial, some business may be prominent, I have no idea. Just things of that nature should be just, the mechanism to do that is to put them on this, potential witness list so that folks can flag it in their answer to the questionnaire.
And this is all important if they go jury trial. If they go bench trial, obviously none of this comes into play because the judge would just hear from the witnesses.
All right, so that's, and then also, frankly, I need to see a witness list sooner than later to make sure that I don't have any conflicts as well. And while I'm thinking of it, I will say this: it's not a conflict in my view, but I will raise. I did see in the file. I thought I saw a report from Dr. Zeisel, and was that on the defense side, right? Because you're
Yes, Your Honor, we have him.
The name didn't sound familiar.
No, okay. So I don't know if he's going to be a trial witness or not, but I will tell you, folks. Mr. Gubitosi may know this. I don't know. I used him a lot when I was a defense attorney. I've been on the bench.
I think that's a reason I personally love this judge so much is he is former defense attorney, which is extremely rare with judges. Typically, you always see prosecutors taking the bench, not defense counsel. So that's one thing I like about this judge too, is that it seems like he understands the defense perspective and his mindset's wired for defense attorneys. So I think it helps a little bit.
8.5 years, and I don't know if he's testified before me. I did keep in touch with him professionally for the first, it felt like the first year or two I was on the bench, just because I still had cases, there were still cases pending that I had been counsel on. But I don't believe I've spoken to him in 7 years or something, but I did want to disclose that. Again, I don't see a conflict at all, but you folks can think about it, and Do you expect that he'd be a witness?
So Judge,
And this is exactly how judges are supposed to be. They're going to put everything out there and ask if either side has an issue. But like he's being so cautious. And I do think that would lend in Kelsey's favor if they go bench trial and the judge is assessing all the witnesses' credibility. Because he has that background knowledge of this guy knows what he's talking about. I have used him in all of my cases, not all, but where mental health was a component. I think it makes sense for Kelsey to go bench trial. I honestly do.
Sort of on the fence about it, actually. That's the number one area that we're on the fence about. But if you don't have a problem with it, we certainly don't have a problem with it.
Yeah, I don't, but you folks will let me know. So on the legal evidence, you know, what motions, like what unusual trial motions should I expect, if any?
I don't think there are really any unusual ones, like bad act motions, things like that.
Yeah.
Nothing unusual from the Commonwealth side. With the caveat that I don't know who their witnesses are or whether they're going to be calling an expert. And that's one of the things I think we need to address today. So.
Oh, okay, yeah. That is a good point. So, because if there's going to be a mental health defense, so I want to keep this case on target for March 23 because, you know,
Agreed.
From my perspective, and I'm sure everyone agrees, if it's not March 23, then that's to the extent that the case is assigned to me, and I don't know if it's been formally done or not done, then I'll be off to a civil session for 3 months, and we'll be waiting. So we've cleared the deck, so to speak, for March 23. So I'd like to make sure that we're on target to do that. But things like mental health defense could slow things up if the Commonwealth wants to hire their own expert, et cetera. So
I understand you are. So I think the Commonwealth has Rule 14 problems, though. You know, they've got to comply with Rule 14 before we have to do anything. And you know, I have a list of, you know, and I know Commonwealth's been trying to kind of work with me, you know, without bothering the court, which is always the best way to go on these things. And you know, we're sort of getting there, but it's going very slow. And I have a list of about 8 things here that, you know, make their certificate of final discovery compliance really not accurate.
So can I ask, I thought I did see, Mr. Kubatosi, from your perspective, is it the Commonwealth's position that you folks have complied, or are there still outstanding discovery issues?
I think the only outstanding discovery issue, and I did reply to defendant's request for his 8 items the other day. I hope he got my reply. It is the ones that we're going to talk about this afternoon.
Okay.
So other than that, there is maybe an issue with I have to provide him a link to something. But other than that.
Okay. All right. Well, I'll tell you what. I put it on the agenda. Let's get right to it. What are the discovery issues?
So, Judge, today,
And did you say that there was a certificate of compliance filed? Because I should.
the last date, Judge, right? And you know,
Mr. Wayne, do you have any idea what? I'm sorry, 50. Okay, I'll just get that out. Just. Fine. Okay, go ahead.
thank you, Mark. So, Judge, today, the Commonwealth is giving me a surveillance system that was taken out of the house. So I appreciate that. We've been looking for that. There's some video. So
They produced
the actual, they took the actual system, right? And we need it for some other cases as well. And we've gotten that taken care of today. The Commonwealth's going to give me that system today. Expert notice. Okay, so with the Rule 14, you know, I don't think we have the proper expert notice in terms of the CV and who's testifying as an expert and what's the opinion going to be. I don't know if, you know, I don't know that I have everything or on that. And I'll elaborate on that a little bit as well.
Okay, well, let's just take them one at a time. Sure. So what kind of experts would there be unless there was a mental health defense? You're talking about like ballistics or something?
Yes, ballistics.
Okay.
I turned over the CV to defense counsel. It's on Axon. He has the report of the ballistician. who analyzed 3 guns and said that 1 gun matches the shell casings that were found on the scene. Other than that, I don't see any other.
But this isn't, the defendant's not charged with a firearm offense, right? It's ADW, is that?
So here's where I'm going with this, Judge. I'm sort of talking about 2 separate things. The Commonwealth has given us a 7-page report, and the report concerns the guns that the responding officers had. It lists 3 Glocks, and they're all the service weapons of the responding officers.
Okay.
So that's great. I'm not interested.
No, that's incorrect. And if defendant, I sent an email to him, February 6th, because we had talked about this. I hate to interrupt, but he's just wasting his time, and
I hate to interrupt. He's just wasting his time. Like, I think you're wasting their time by bringing this case when you have to know this case is just a bunch of baloney. I understand, like, if they feel this way, but they have to come to the realization and they have to know that this case will never be proven beyond a reasonable doubt when it's 100% he said, she said. Like, their assessment of this case is so out of touch with reality, but this guy just triggers me. The way he speaks. Ugh.
Go ahead, I'd like to hear from it.
And in the email, I talked about which gun was which gun. There was 2 officers who were on the scene, one the shooter, one Officer Noonan, who.
Not him having a Freudian slip, or however you say that, saying the shooter, and then he quickly corrects it. I can't even speak, and says Officer Noonan. Like, right. He was the shooter that shot her. This case is so twisted and backwards, it's truly bizarre.
Discharged his firearm, another officer who did not discharge his firearm, and the gun that the defendant is alleged to have. Yes, who is alleged to have used. And that was her service weapon. And I detailed for that to defense counsel. And so the analysis that was done on the gun that was involved in the shooting. So that's all.
So this would have been, what was the officer's name?
Noonan.
This would have been Officer Noonan's service weapon.
Yes, and so I had sent an email because we had been talking about that on February 6th concerning that exact issue to clarify for defense counsel.
Okay.
So
Yep, go ahead.
I appreciate counsel interjecting with that. And if it's, I'll go back and look at it, but I read it to be the 3 officers that were at the scene and that their guns were taken pursuant to protocol. But if the Commonwealth is saying that that's the gun that was used, then that's fine. And I'm satisfied with that. I didn't read it that way, but if that's how the Commonwealth has it, I'll go back and look at it, and that's fine. So that's we can take that one off of this. Body-worn cameras, Your Honor. There were an officer visited Ms. Fitzsimmons early on when she was at Mass General Hospital. She spent 53 days at Mass General. An officer visited her there. And I don't know if there's a report that emanated from that or a body camera that emanated from that. And then,
so when you say body camera footage, it's very narrow. You're saying, like,
right.
There's a specific event or
right. It was one officer that visited her at the hospital, right?
Okay, and was this a social visit or something?
That's a good question. It might have been half and half. I'm not sure.
And, would this have been a North Andover officer?
Yes.
State police. Okay. So.
Yes.
So to me, this sounds like North Andover sent an officer to Kelsey to check on her, but was really like fishing for information. Shh, Baba. That's what it's giving to me, is that somebody came fishing. Kelsey, being in a vulnerable state, may have opened up. And then now it's like, we see what they were doing here. So I find this interesting. Now we know North Andover does not have body-worn cameras, but I think him putting it out there is like, we want anything that you have that has to do with this social visit / fishing for information / interview. That's what I think he's trying to say.
And have you told the Commonwealth the identity of the officer?
It actually might be the trooper. If I could just have one moment, sure.
And now we see Kelsey telling Bradel who it was, what it was. So let's hear what he says.
Dan Furman.
Right, and I don't, who is that?
So he visited Ms. Fitzsimmons at the hospital, and if there's any,
I'm sorry, I meant, when I said who's that, I meant what police agency?
so there's a visit from someone who's might be a social visit or a police visit. I don't know what it is, but I'd like to know if there's any documentation of it.
All right, so this, but again, this person's name, this officer, detective's name.
Furman, F-U-H-R-M-A-N.
Okay, and
Not a Furman entering the chat. Taking it back to OJ Furman.
what police agency does he work for?
North Andover.
All right, and so this should be, well, and you're saying that you don't know if it was a social visit or not?
All I know is the North Andover police officer visited.
And this is totally fair for Bradel to be like, I don't know what it is, because this was in the days after she was shot and recovering. So she truly was on medication. She truly could not remember, or maybe she thinks she's forgetting part of it. So like, I think it's totally fair for him to ask for this because she was in a vulnerable state and I'm assuming heavily medicated. So who knows what she remembers, and also who knows what she said.
Visited her, and is there any documentation of it, or is there a report? Is there a text message from it? Is there anything from it? I just want to know.
I'm not expecting any answers right now. I'm just, do you want to weigh in on this?
No, that's the first I've heard of it, and I don't think the defendant would know if it was a social visit or anything more than that. I don't believe North Andover has body-worn cameras, but I will certainly.
Like, it's so disingenuous for him to stand up and say that when we know what state she was in, and him being like, well, his client should know. It's like, well, she might forget. She might not even remember that visit happening.
Okay, this is the first I've heard of that. So.
All right.
And then there's also office wanting to move the case along and get her arraigned. And there should be body camera from the state police from that.
All right, so is it?
And I believe that's true. It's strong.
Is this request, are you familiar with this?
It was my understanding that defense counsel called me and asked that there not be body-worn camera when the state police went to her. So, but I will double check that. So.
Okay.
Well, my client tells me that there was body-worn camera that was activated, and that she was informed that there was body-worn camera.
Okay, well, if there was, then it sounds like it wouldn't have been North Andover, so.
No, that's state police.
State police,
Is,
yes, trooper strong.
is here today. I'll ask him.
Okay. All right, and you know what, excellent, because if the troopers here, to the extent that we can put any of these issues to bed today, that would be great. So what else?
Promises, rewards, inducements, Your Honor.
I so appreciate this judge being like, let's get answers. If they're here, we're going to figure it out and get to the bottom of it, instead of just pushing it over or giving Gubatosi free reign to check on it and then never follow up on it. So I appreciate the judge being like, nope, if he's here, we're going to figure it out. And now we're moving to the promises, rewards, inducements, which was the motion Bradel filed about that let out all the bombshell evidence of Justin Alayan breaking and entering, stealing her money, stealing her laptop, taking the security system out of her house, all of that. So let's hear what Gubatosi has to say on this.
That's the subject of an entire filing today.
Okay, so we will, do you want to do that now, or do you want to, what else is on your list? We'll circle back.
That's the list, Your Honor.
Okay. All right, but I want to make sure I'm not missing anything, because didn't you say that you had 8 things and I only had 4?
So I'd like a witness list from the Commonwealth. I'd like to move to strike the certificate of discovery compliance to the extent that it triggers our obligations when their discovery obligations are not satisfied.
And by the way, pretty quickly, I don't have these rules about, I have a case in front of me now where there's 3 DAs and 3 assistant DAs and 1 defense attorney. You're all welcome to speak, so to the extent that,
Like, I love this judge. He's like, we're going chill in my courtroom, and I just love this judge.
I'm not, I don't have rules against more than 1 attorney speaking. So
I appreciate that, Your Honor. I'm not afraid to speak.
Attorney Riddle knows that. No, you're not afraid at all. I don't want you to, anyone to think that, to the extent that you want to be heard, you can be heard.
Thank you. I appreciate that.
What else?
Judge, there's also some OneDrive links that I know that I think the council referred to that. There's some OneDrive links for some discovery that we don't have. That we got some apps on discovery that had OneDrive links in it, and it was not communicating very well with our computer. So council is going to get me OneDrive links for, I believe, you said one more. So I'm actually at a loss to say what's on.
Like, look how old this courtroom is. Number one, the blue paint is hideous, but also like the old school chalkboard. This is an old courtroom.
These OneDrive links because I can't open.
Okay, all right, well, that's, Mr. Malcolm, because do you know anything about?
Yeah, as I had said just a few minutes ago, I understand what he's looking for. I understand, and we'll send him the link on Monday.
Okay. All right, what else?
I believe there were some redactions in the grand jury minutes that were given, Your Honor. And if there are any redacted grand jury minutes, we need the unredacted grand jury minutes.
I've never heard of that, but.
Right, I didn't, yeah, it was strange.
No, and I tried to explain this to counsel. When he
Like, see what I mean by he's so demeaning? He immediately pops up and he goes, now I tried to explain this to him, as if Attorney Bradle's incompetent to understand what he allegedly explained to him. It's just like, we don't need that extra commentary from you, Gubitosi.
he got a redacted exhibit that I used in grand jury. And it was an interview with some of the officers that talked about things that I thought were too prejudicial to the defendant. And so I submitted to the grand jury.
This is so fake. Whenever have you heard a prosecutor say he thinks evidence is too prejudicial to the defendant? Normally, a prosecutor will muddy up a defendant any chance they get.
Their consideration, the redacted exhibits.
Okay.
However, he has the full exhibit also, meaning a full unredacted version of those recordings.
Okay.
So the grand jury minutes themselves, I'm sorry to interrupt,
No, no.
are not redacted.
Okay. That's, if I have it, I'd like to have it.
Yep.
Okay. So, yeah, I mean, it sounds as though Mr. Gubitosi has produced them, and I'm sure will, if not, with both the redacted and the unredacted versions, so you'll have a record of what exactly the grand jury saw, if you don't already.
Thank you.
What else?
The rest is the promises, rewards, inducements motion, Your Honor. There's 2 key pieces here that are.
All right, so we're ready to go
Yes.
to the motion. All right, so let me just cue that up. Where's my notes? So it's been docketed as paper 53, defendant's motion for disclosure of promises, rewards, and inducements. And I have read it. I've read the attachments, and I don't know if this is an issue for Mr. Gubitosi or not. But I'll say that the problem that I saw with the motion is that it's not supported by affidavit. And I don't know, again, if that's something that the Commonwealth would raises or not, but to the extent that you're relying on statements of your client and your client's father, I typically would see that in an affidavit form. Is that it?
Well, Judge, I do have an attorney's affidavit, and I do, at the end of the motion, but I do view it more as like what we're doing here from the defense side is we're pointing the Commonwealth to specific exculpatory evidence.
Right.
So, how far we have to go with affirmative, averments of that, I don't think it's not like a motion to suppress where we're asking for the court to, make significant rulings. This is a notice to the government that says, hey, look at all this stuff that has happened. And, you need to figure this out. And I think that the government, in this case, with respect to this Alain guy, has rose-colored glasses on where they're like, they don't want this guy to be harmed. They think this is a probate court issue. They think this is, just focus on Kelsey. Let's not worry about this guy. Don't look over here. Don't look behind the curtain. So this is an incredibly egregious thing this guy did. Miss Fitzsimmons was in the hospital fighting for her life. That was her home. He had gone and gotten a restraining order in which he swore in the affidavit, I don't live there. I live in Stowe with my parents. He's now a plaintiff against Miss Fitzsimmons as a defendant in a restraining order matter. He has no rights to that house whatsoever. 3 days later, her dad, who's a security expert and owns a security business, changed the locks, updated the security system, made his daughter's home secure again after this thing happened to her. And after the shooting, and she's in the hospital. She's away from her house. And this guy takes advantage of that to commit all sorts of serious crimes. He's on video, breaking into the place with 3 other friends, 3 other accomplices, bust down the door, come in, it's on video, it's in an exhibit that you have.
Guys, I need to quit getting.
Commits all sorts of serious crimes. The most serious one for purposes of this case is that he stole evidence. He stole evidence off the refrigerator. It's a felony. He had just.
Can I ask you something?
Yes.
Assuming everything that you say is true, the motion is for promises, inducements, or rewards. So your theory is what? That the Commonwealth promised to not charge this guy or something?
Yes. That's exactly what we think. And he's a precipitated witness. He's at the scene of the shooting, Your Honor.
I genuinely want nothing more than to see Justin Alain on the stand and cross-examined.
He's at the scene of the shooting. This isn't about, 3 days earlier he did this order. It's that he's a precipitated witness at the shooting. He's there. He and his sister are there.
At the end of the day, the motion is for promises, inducements, or rewards. So
Yes.
As those terms are understood, has the Commonwealth made any of those or offered any of that to this gentleman?
I think
Oh boy, here we go. Let's see what he says.
I can answer it this way. Okay. As far as him being a recipient witness, and you don't know very little about this case, the 2 people who were there in the room when the shooting occurred, when the allegations against the defendant pointing the gun at Officer Noonan and pulling the trigger, and him shooting her in self-defense, the 2 of them were up there. That's in a top floor bedroom. Mr. Alien was in the basement at the time. He's on surveillance video in the basement. He hears it, he leaves. So he's not a recipient witness. I'd just like to put this up there. That the case does not rise and fall on him. He might be a background witness. He heard the shots, but as far as what happened in the bedroom, he has no idea. So to say he's a critical recipient witness, I would suggest is a little misleading.
But whether he's critical or not, there's either.
And I agree. And but I just have to correct the record.
Sure.
Now, defense counsel sent my office a packet of information, including, and we had the video of, oh no, we didn't have the video. He sent video of Mr. Ali, I'm going to call him Justin. I apologize. I'm having trouble with his name. Entering the house.
He tends to call Justin Alain Justin Alien.
On a specific day. And the Commonwealth, and what is omitted from the defendant's argument, and he has this, and he knows that the day before this happened,
It's like, why do we have to add so much commentary?
Justin called the North Andover police and asked if he could enter the apartment. He told them that the defendant was on the deed, but he had property there. And they told.
See, and this is where it gets so fishy to me. Like, he called North Andover, called up his buddies, and got permission to break and enter. How is that okay?
Told him he could go in. On the next day, where this video is, he calls again and says, I need to go into the apartment to get my stuff. He asked for a police escort because he's afraid of what the defendant and the defendant's family would do.
Because everybody fears Kelsey Fitzsimmons. The little Kelsey Fitzsimmons is so scary. And he keeps calling it an apartment. It's not an apartment, it's a house.
If he went in there, he was worried about his in his words, vengeance. Okay? And so he does go in. He does push the door open. He goes in to
Imagine if this was anybody else
retrieve.
pushing the door in. No, it's not pushing the door in. It's busting the door in. But look at how he's trying to minimize this.
His items.
With the police escort?
No, the police didn't come. At that point, the alarm went off because I'm assuming there was some surveillance video in there and an alarm system.
Sure.
When the alarm goes off, he calls the police and he says, can you come here, please? The alarm went off.
What an outstanding citizen. He calls the police after he breaks and enters and the alarm goes off. He is just a top-notch citizen.
I'm worried that the family of the defendant will come, and I'm worried what will happen because they're very vengeful about the whole situation.
Okay.
And they said, we're not coming, but if he shows up, let us know and we'll come and keep the peace. He then gathers his belongings and left.
Okay.
So we can't look at a crime. The Commonwealth, in any case, does not look at the crime in isolation. We have to make determinations when we're looking at cases. Okay. Justin.
I mean, like, wouldn't you be vengeful too if you went and got a restraining order behind your child's mother's back with a 3-month-old baby and you filed this false affidavit in court and got the baby taken? Yeah, I'd be vengeful too.
Has also filed an affidavit in court.
In this court or in the?
No, in the probate court, as the restraining order, which 3 judges have not been found credible. And the defendant has yet to litigate that motion. And so we have information from the defense about what happened, about this breaking and entering in this supposed theft of evidence, and that's the first I heard there was evidence.
This is wild to me. Supposed theft. I wish we would have kept track of how many times he did air quotes. His belongings, aka her computer, which he then hacked into her bank accounts and drained them, stole her security system because he wanted to take evidence. I mean, from the house, that is considered evidence. What else did he steal? Her passport. I mean, that is theft. There's nothing alleged about that. He had no permission to take her stuff.
We had that packet. We reviewed it in an abundance of caution. We asked Middlesex to look at it, and they were going to take a look at it. At that point, Attorney Coakley called Middlesex, the first assistant, about that. Middlesex then called us and said, we can't do it. We don't want to take a look at it. We think we have a conflict now. So our office then looked at it, and we determined that we are not going to charge Mr. Alien for these crimes. I don't know if he
Mr. Alien. And then at some point, Justin tries to justify this as he needed stuff for the baby, but right, because you got this fraudulent temporary restraining order and you weren't even fit to take the baby.
He even knows that this is out there. I don't know if he even understands that there are charges that the defendant is alleging occurred. I haven't talked to him about that. If I do, and if he has a concern, I'll tell him that we're not charging him with that based on the entire circumstances of this case. The Commonwealth is often in the position of analyzing cases when there are dueling issues and dueling statements. And we have an obligation to parse those out. And if we don't believe there's probable cause, we don't charge. That's what we have here. The Commonwealth has made the determination.
You don't believe there's probable cause when it's all on camera? You're kidding. I never want to see a breaking and entering charge for somebody breaking into a gas station or a bank or anything. Give me a break. It's all on camera. That's plenty of probable cause. That's beyond a reasonable doubt. That's literally direct evidence that he committed these crimes.
Not in isolation, but in the whole circumstances of this case, that we are not going to charge him. If at some point during the case, Your Honor thinks he has a fifth, we'll immunize him. But we haven't told him that. Defense counsel is now on notice that that is our position.
Oh, just go commit all the crimes you want, Justin. Don't worry, we'll immunize you. Have no fear, we're here for you.
So is it a promise, award, and inducement? It is what it is right now.
Okay.
So they're on notice of that.
All right, so, Mr. Prado.
Yes.
Let me see this.
A laundry list of crimes Justin committed, and his response is, it is what it is. Y'all, I can't.
The whole idea of the of discovery, obviously, disclosure. It sounds like perhaps this is the first time you've heard the full version from the Commonwealth's perspective, but to the extent, now probably isn't the time to determine whether it's a promise, inducement, or reward. I think now is the time to determine the sufficiency of, assuming that it is one of those three things, the sufficiency of the notice provided to you.
Absolutely, that's what we're interested in, Judge.
All right, so.
Communications.
All right, so it sounds as though, so what is it further that you're looking for? You want something in writing that they're not gonna?
So just a couple of quick things, Judge, as far as what Cromwell said. I have the call that he made to North Andover, to one of the sergeants up there, I believe Sergeant Gerke, I may not be saying her name right, but we have the call. And in the call, he's committing another felony called misleading police. He's saying to her that he still lives there and that he wants to get in there and he's looking for a dispensation from them.
So which one is it? You lie in the affidavit to get the baby taken, and you are the reason this whole chain of events happened, and you put on an affidavit that you did not live there, and now days later you're committing crimes and claiming you lived there.
Let him get in there. And he lies to her. And he says that he still lives there. Completely contradicts what he already swore to the probate court judge, family court judge, to get the restraining order. And so the sergeant, I think, does the right thing and says, well, if you have a key or, if that's your house, I can't stop you from going in your house. But she doesn't say, yeah, you go right ahead and go in the house. She's deflecting.
Nicole, literally, he says what you just said.
And saying, well, you're telling me you live there, I can't do anything about it. So it's this sort of round and round conversation where he's trying to get dispensation from them. And she wisely just says, well, if it's your house, go ahead, but I don't have anything to do with it. That to me is just the conversation that I have. So there's yet another crime that we're looking the other way on for this guy. But in any event,
Mr. Prado,
so I'm sorry, because I'll tell you what I'm looking for. Ready? That's it, please. All right, I'm sorry. So I'm looking for text messages, emails, notes to, what is the police, what is the DA's office, what are they saying about this incident that they know about? Are they saying, don't worry about it, we're not going to prosecute you? I want the communications. What are they saying? I can't, it's always hard for me.
Which is fair. He's saying, I want to know what the behind the scenes talks are, because they have proof of him committing these crimes on camera, and yet they're sitting there choosing to not do anything. And the way this motion is, like, it's not like he was given an immunity agreement. So Bradel's kind of in a way fishing, but like rightfully so. He should know this information. But at the same time, the prosecution is like, well, we're just not doing anything. It is what it is. So there's nothing to give. So I think the way the motion is, like, of course, Bradel had to craft this in a way that fits the legal standard and the law. But the prosecution's just like, well, we're not doing anything about it. So there's nothing to give you. And Bradel is like, there has to be something because this dude is committing crimes. So you're really just like, I think he knows there's more, and that's what he's asking for.
Defense perspective to, guess what's out there. They should be giving me, here's all the communications about Elaine and him breaking into the house and why we're not prosecuting him, and this whole business about that, he checked with the police, he lied to the police. So he didn't check with the police. So their facts are all wrong. And he should be prosecuted, and they're in a conflict of interest, and the court should direct them to appoint a special prosecutor because they clearly have a conflict of interest in trying to prop this guy up for their own case. And so they ought to be ordered by the court as a matter of ethics, as a matter of appropriate behavior as an attorney to appoint a special prosecutor. And I want to ask the court to take a serious look at that.
Let's do this. Can you, can Ms. Fitzsimmons as well, come on over to the sidebar for a moment.
Oh, that sidebar sound is awful. Okay, we're almost done here. Let's see if they come back from the sidebar at all. And it doesn't look like they do. That sound is horrible. Yeah, so it looks like that just ends the hearing, which you would think they would come back on the record and finish the hearing out, but okay, of course, I've been sitting here yapping, and I was muted. So that looks like it finishes that first hearing out. It's really bizarre how they go to sidebar and then just bam, the stream ends. You would think they'd come back and say, like, hey, court's in recess, but they don't. So basically, this hearing today sets us up for the much longer hearing we will watch tomorrow. That's like, goodness, the stream itself is like 3 hours long, but there's definitely a lot of dead space in it that we can zoom right through. So real quick, I start a couple chats. We'll go through them, and then we'll be done for today. Not much really of substance in this hearing, but I think this hearing was important to prep us for the next hearing where this whole Justin Elaine motion is hammered out more. So Emily says, I guess he's part of the North Andover Good Old Boys Club and no one cares to hold him accountable. Exactly. 100% what it is. Hang on a minute. Mason's being really loud. Bubba, don't yell. Nicole said, question for later. She had cameras in the home. Did they catch any video audio from that night? That's a really good question, and I do not know because the system that caught Justin breaking and entering was a new system her dad had just put in after the shooting happened. I don't know what she had before or what picked up on it. I'm guessing if there was anything, Justin would have tipped them off to that and told them. So maybe that was tampered with. We really don't know. That might come out in later hearings. I don't have an answer right now. So we'll save that and be on the lookout for that answer in the next couple of hearings. Tegan says she is at her mom's and can now see her kid right. No. I don't want to give spoilers for the next hearing, but there's been so much reporting. Madeline, I'm almost done. Please stop. She was granted the bail modification where she was able to go get her own condo. And that was basically asked for by Bradel because they have a family court hearing coming up right after trial within the next couple of weeks. And she wanted to be able to walk into probate court and say, I have my own place. Can we start reunification between me and the baby? And so she was granted that permission. So she's not at her mom's anymore. And she cannot see her kid. What the judge did, which we will hear again in the next hearing, so sorry that I'm giving spoilers. When she had her bail conditions originally set by McCarthy Naiman went out of her way to put an additional restraining order on Kelsey between her and the baby, which is really bizarre. That's not a criminal matter. That's nothing the criminal court should have been involved in, but she did it anyways. The judge removed that second order and just left it as in the discretion of the family court. So Kelsey is to abide by whatever orders are in the family court. So it was almost like peeling back one layer and getting her one step forward, but she has not been able to see her baby yet. And when she's able to, it will definitely be a reunification process where it might start with supervised visits and work its way up to her having the baby back in her care unsupervised. Emily said it could depend so much on the jury's view of police officers. I starred this because this case is so unique that she was also a police officer. But again, I agree, which I think is partially why a bench trial could be beneficial to Kelsey, just to eliminate all of that extra noise that juries come in with, like the preconceived opinions and thoughts. All of that is just eliminated when you go bench trial. And then last one, Stacy said, hang on a minute. Stacy said, what about the video of him smoking something behind the shed? That was also retrieved from the news system. And it's curious because that all came out and then within days, Justin's put on leave. And in Massachusetts, marijuana, all of that is legal. So it's not that he was committing a crime by doing that, but he's a public servant. He's a firefighter. That goes against their own policies and procedures that, like, you can't be doing that. And Bradel brought up, like, these times are conflicting with times that he should be at work doing his public servant job. So there has to be some internal affairs investigation. There has to be something more to it because the times align with him being or heading to work, that type of thing. So that video did come out, and we'll hear more about that in the next hearing, I think, because that gets brought up in a motion in limine where I think the state is asking Bradel not be allowed to question him on it. So we'll get that more in depth tomorrow. Okay. Okay, I might have forgot to hit mute. See, the microphone has a mute button too, and so StreamYard has a mute button, so I don't know. I must have forgot. Madeline's like ready to go. She always wants to leave for school like an hour before school starts. I'm like, we're not going to sit in the line for an hour, honey. Like, just go play. Oh yeah, he just lives his best life. Like, he's in his own world with his dinosaurs and his monster trucks, and he can't be bothered. He is so independent, and she's not. Okay, guys. So we got this done in under an hour and 15 minutes, which is perfect because now in the next 15 minutes, we have to leave to go to school. So this hearing was basically a nothing burger, but also added context that we needed moving forward. So hopefully we can like store this in our little brains for the next couple of hearings. And we will be back tomorrow morning to go over the next hearing in chronological order. But yeah, thank you guys so much for being here. Hi, Stacy. Thank you. Hi, Nicole. Thank you. As always, Tegan, Emily, all of you, Abby, who I saw in the chat. So that's it. I hope you guys have a great, what is it, Wednesday? Are we at Wednesday? Yes. A great Wednesday. I will chat with you all later, and I think I'm going to do some more case updates. Aaron Spencer was in court today. I need to go find the reporting on that and update. So I'll be updating on stories on some of our other cases we're following. Thank you so much, and I will see you all tomorrow. Bye.
Thanks for watching. Make sure you hit the like and subscribe and follow me over on Instagram at Life with Kaylee.